Could one of the Renters' Rights Act's biggest unintended consequences be a sharp rise in the number of tenants needing a guarantor? The new legislation is designed to make renting fairer and more secure. But as one door closes, another may be opening. Research from Zero Deposit suggests that significantly more tenants could require a guarantor in the years ahead, particularly as landlords lose the ability to rely on large upfront rent payments when assessing financial risk. At first glance, the issue appears straightforward. If tenants can no longer offer 6 or 12 months' rent in advance, landlords may place greater emphasis on affordability checks and guarantors instead. But there may be a second, less discussed consequence. At exactly the same time that landlords could become more reliant on guarantors, the legal foundations of many guarantor agreements are becoming more complicated. According to Zero Deposit, average rents now require an income significantly above average earnings in many parts of England. If affordability thresholds increase, the number of tenants needing a guarantor could rise substantially. For many renters, that may not be a problem. For others, it could become a significant barrier to securing accommodation. Not everyone has access to a family member or friend willing and able to act as a guarantor. Younger renters, overseas applicants, self-employed workers, and those moving to higher-cost areas may find it particularly difficult. But what exactly is a guarantor? Most guarantor agreements are executed as deeds rather than ordinary contracts. In simple terms, a guarantor makes a legally binding promise to cover the tenant's obligations if the tenant fails to do so. For many years, guarantors have been a common feature of the private rented sector, particularly where tenants have limited income, limited credit history, or cannot satisfy affordability checks. However, guarantor agreements have never been completely straightforward. One of the most important legal authorities in this area is the case of Holme v. Brunskill, decided in 1878. The courts established an important principle: where the underlying agreement is materially altered without the guarantor's knowledge or consent, the guarantor may be released from their obligations. In simple terms, if the tenancy changes significantly, a guarantor may argue that they never agreed to guarantee the revised arrangement. A common example is a rent increase. If a landlord increases the rent and the guarantor is neither informed nor asked to agree to the change, questions can arise about whether the original guarantee remains fully enforceable. This issue existed long before the Renters' Rights Act. However, many housing professionals believe the new tenancy framework could bring the issue into much sharper focus. Housing lawyer and landlord law specialist Tessa Shepperson has highlighted concerns around clauses that attempt to bind guarantors to future rent increases, noting that some provisions may face challenges under consumer protection legislation, where the guarantor has not expressly agreed to the revised terms. At the same time, landlord organizations, including the National Residential Landlords Association, have been encouraging landlords to review their guarantor documentation carefully. The reason is simple. Under the previous system, most tenancies began with a fixed term. The guarantor knew the rent, knew the duration of the tenancy, and understood the arrangement they were guaranteeing. The Renters' Rights Act fundamentally changes that model. Instead of fixed-term assured shorthold tenancies, the sector has moved towards periodic tenancies that can continue indefinitely. A valid Section 13 notice must be served before any rent increase can take effect. That means the tenancy may evolve over time, creating a more fluid arrangement than the traditional fixed-term model. As a result, housing advisors are increasingly recommending that guarantor agreements are drafted specifically for the new periodic tenancy framework. Many are advising landlords to use properly drafted deeds of guarantee, ensure guarantors understand the tenancy they are guaranteeing, and include wording that specifically addresses future rent increases and tenancy variations. Some advisors have gone further, suggesting landlords obtain fresh written confirmation from guarantors whenever significant changes occur, rather than assuming the original guarantee automatically extends to every future variation. None of this means guarantors suddenly become ineffective, nor does it mean that existing guarantees automatically fail. What it does mean is that landlords may need to pay much closer attention to how guarantor agreements are drafted, managed, and updated if they want those protections to withstand scrutiny should a dispute ever reach the courts. For tenants, the position is equally interesting. The Renters' Rights Act may increase reliance on guarantors at precisely the moment that guarantor arrangements are becoming more legally complex. The result could be a rental market where more tenants are asked to provide guarantors, while landlords become increasingly cautious about whether those guarantees will actually stand up if tested. The industry is already exploring alternatives, including insurance-backed products, guarantee schemes, and other forms of financial protection. What seems clear is that the conversation around guarantors is changing. The debate is no longer simply about whether a tenant needs one. It is also about whether guarantor agreements drafted for the old tenancy system remain fit for purpose in a world of periodic tenancies, Section 13 rent increases, and evolving consumer protection rules. As the Renters' Rights Act continues to reshape the private rented sector, this is likely to become one of the most closely watched issues for landlords, tenants, and letting agents alike. And perhaps the biggest question of all is this. With rent in advance restricted and guarantor agreements facing greater scrutiny, an important question remains. Has the Renters' Rights Act reduced landlords' traditional risk management options without providing a clear alternative?